My name's Jeff Morgan. I'm back here again with David O'Connor. David, thank you so much for coming up today. I appreciate it.
Oh, thank you for having me, Jeff. I really appreciate it. It's my honor.
Absolutely. So can you give us an update about where your case is right now? For those who don't know, David, why don't you give a brief recap first so they have a little bit of an idea what you've been going through. And I want to just say that I appreciate so much that you're fighting.
Well, as you know, there is a custody case going on concerning our little boy, and I think our last hearing that we were to have was on October 17th, but we removed our case to federal court due to discriminatory allegations of discriminatory actions by the other parties involved in the case.
Okay.
So currently our case is in federal court right now.
Okay.
And and of course, since that time, there's been a great deal of information learned, I think, by all parties, including myself. One of the most salient points with this is the child custody evaluator, Alissa Sherry, who produced this report. And regarding me, she created this narrative of just awful false statements that were very inconsistent with the objective psychological testing. And the objective psychological testing regarding me basically was essentially normalized. The psychological testing of the mom showed that what was classified as having a thought disorder and some significant problems that Alissa Sherry attempted to cover up. And not only defraud the court, but cause injury to myself, and by the cover-up, not have the serious issues of the mom paid attention to, which could seriously affect the child.
I was going to say, does that also constitute some type of child endangerment, perhaps?
Perhaps it does, because the child is being exposed to the primary custodial parent that has these significant problems that are described as a thought disorder and with significant paranoia issues, which I've encountered different behavioral aspects of throughout the relationship with her. But the court is also ignored. So the report came out in January. I think we spoke about that before.
Right.
And Marshall Thompson, who's the opposing counsel, with Thompson, Salinas, and Lundergan, based in Austin, Texas, attached this report to a motion for temporary orders and a motion for interim attorney fees, not surprisingly.
Well, of course.
And this occurred back in February. Now, apparently, since that time, it's now public record because it was filed with the court. Okay, good. The thing that wasn't originally filed with the court was the objective testing results. In the objective testing results, contrary to state statute and the orders, were not included in the report. Okay. And I believe that that was done purposely. Okay. As we know, anytime there's a court paper being filed, there's an obligation and an assumption that the attorney that's filing that paper knows the content of any attachments, knows the content of the motion or the paper to be true or correct, and is filing it with the court to be true and correct. So obviously, Mr. Thompson knows or believes that that report is true and correct and not fraudulent. But he filed it on his motion for those two motions.
So I want to ask you a quick question about that, because Marshall Thompson is not an expert in these areas. So could he plead ignorance and say, well, I filed it and I thought it was correct, and basically have a way to excuse his own behavior, his own filing, and basically just say, well, you know, I can't be held liable for this because I didn't know. Can he do that?
I don't believe he can, actually, because he's ultimately responsible for the veracity of any statement that's filed in a motion.
And even if say it works, it just shows that there's a lot of these attorneys out there, these high-priced attorneys, who don't have expertise but act as if they do, which I also believe constitutes fraud as well. But I'll let you continue on.
Okay. So the report is attached to the motion, and subsequently in the months to follow, with the subsequent hearings, I actually filed motions which included the objective testing results.
Okay.
there was a filing by me of an original petition against Alissa Sherry. And then subsequent to that original petition, Alissa Sherry attempted to file a temporary restraining order affidavit. And she is apparently to be the neutral, court-ordered child custody evaluator, but took it on her own accord and stated as such that her affidavit was written by her and originated by her. And of course, it was not a well-balanced affidavit, and of course, it had a lot of fraudulent information in it as well.
Right.
But it was attached to a motion for a temporary restraining order by Marshall Thompson of Thompson, Salinas, and Lundergan, based in Austin, Texas. So there again was an affidavit, and of course an affidavit is just the same as a testimony to the court.
Right.
And this testimony to the court was attached to a motion for a temporary restraining order by Marshall Thompson. So thank God the judge did not approve it, and I think what happened is that the judge who was involved at the time reviewed the temporary restraining order motion, as well as my countervailing affidavit, as well as the subsequent documentation, and decided not to approve the motion.
Which judge was this?
This was Judge Hexel.
Okay.
And I think she made a wise decision. She saved the relationship of our child with his father, and still preserved automatically the child's relationship with both parents. Interesting to note, in that affidavit and motion of the TRO, Alissa Sherry and Marshall Thompson included the objective psychological testing results of both mom and myself. And it's clear, not only from my reading, just blatant reading of the objective testing, but also two other experts reading of the objective testing, that Alissa Sherry's narrative was clearly fraudulent in her descriptions of me and her descriptions of mom.
Wow.
Compared to the objective testing results.